Namaskar all. Today we will start our session with a legal Latin maxim. You all know what is maxim. That is rarely used nowadays in the court. But if it is used, it is law makes lot of impression before the court. In the High Court and Supreme Court, you will hear this maxim. And when you hear, you actually can impress the judges and also the litigants and the opposite counsel equally. There's one Latin maxim I would like to start with, dominus litis. The word domin, you can understand, dominating, is the master of the suit. So who is the master of the suit? Who will decide where and which jurisdiction the case will be filed? There are legal provision in the Civil Procedure Code, CRPC, that is Criminal Procedure Code for criminal matters, as the name indicates, civil and criminal, and now under new law in the BNSS, Bharatiya Nagrik Suraksha Sanhita. Now, it is not important to remember section, but it is important where to file the case for the transfer. Now, when you speak about dominus litis, it is the plaintiff's right or the complainant's right. In civil, of course, it's a plaintiff right where he would like to file the case, and it will be his prerogative, I would say, that he would see his convenience and even the court will support. That is, I'm speaking for the civil matters. But there are cases where in the criminal trials, the cases are transferred not only from one place to another, but from the one state to another state. This has happened. Now, how this transfer takes place? One, the parties themselves go to the court for the transfer, and the second, the parties, if the party do not go, one of the parties, then possibly sometimes the suo motu the court take the cognizance. Now, one of the best example I can give is the Best Bakery case of the Gujarat. Now here, what happened? It was a criminal case, and all the accused were acquitted, and the matter went to the Supreme Court, and Supreme Court said that for the impartial trial, the case has to be retried. Not only it was transferred, but it was retried in the state of Maharashtra. So do go through the Best Bakery case of the transfer, and also it is one of the important case for the retrial. You may not have a word retrial. Retrial means the complete trial will gone. So now this is one case you must read, that is of the Best Bakery case known as. And very recently, two of the accused, later on they were caught, and they were also were tried before the at the Maharashtra before the special court. Now, see, civil case, it is very easy. Normally, if we go to matrimonial dispute, the wife resides at Hyderabad. The husband files a divorce case at Delhi. Now the wife has children, and she says that I cannot travel, leaving my children to the Delhi. Now, Delhi and the Hyderabad, they are in two different states. One is Union Territory, and the when it is two different states, the matter will go to the Supreme Court. So always remember, if it is like Gujarat and Maharashtra, it is not Gujarat High Court, or it is not the Bombay High Court, which will have a jurisdiction in matrimonial disputes, or for that matter, any matter. When the matter is before two different states, it will go to between the two different states, two litigants who are staying in different states, it will go to the Supreme Court. Now, suppose we take an example of the Maharashtra. There is one case in the Mumbai, and the wife is case is filed here, and the wife is residing somewhere at Nandurbar or Amravati. Now this comes under the Maharashtra. So the transfer of the case will be done by the Bombay High Court. You have to make an application there. And now this will go like same like this will be applying to all the civil cases as well as criminal cases. Under the old law, CRPC, it will be 406 onwards. And under BNSS, if it is a new case now, normally which will happen now, that's 440, section 446 onwards. Now, suppose there is one more thing I can share here. That is, if the case is itself in Mumbai and the matter is between two district courts, then it will go to the again to the High Court. But if matter is between the JMFC or MM court, then these are two subordinate courts. Then their district court it will go. So actually, it is very easy. Transfer of the case is very easy in civil matters. But you should make out a good ground for the transfer. And once you make out a good ground for transfer, the court will definitely transfer. I have seen transfer from Madurai to Mumbai, Hyderabad to Delhi. But all depends on how you give the good grounds. If the ground is good, the court will definitely help your client to get transfer. Now, this is about civil cases. Matrimonial disputes also falls under civil cases. What about criminal cases? Is it so easy? In criminal cases, it will be very difficult to find more example in criminal cases. The reason is the witnesses, the investigation, the police station is at the place where the offense has taken place. Normally, the court will not transfer criminal cases unless you show a strong reason. Suppose witnesses are intimidated, like in Best Bakery case, the court found that witnesses were intimidated, they all turn hostile. Or the complainant feels, the person who lodged the complaint feels unsafe to travel there. Then in such cases, it is possible that court may transfer, but in criminal cases, it is actually very difficult to get the matter transfer to the another place. Best Bakery case is one example where you can definitely find good reasons for that. And there are many civil cases you will find. Now, there is one judgment I would like to read today here. Vandana, this is not for you. Wait. So they will understand what is actually I was talking about a transfer. Now this is one case. Plaintiff is the, can you see the screen? Plaintiff is the dominus litis, the maxim I used in the beginning. In Srimati Pomi Sengupta versus Bispajit Sengupta. Now see, I'll go through this paragraph. Just a minute. The provisions under section 22 to 25 of the Code of Civil Procedure Code are the appropriate provisions in regard to transfer of the proceedings from one court to another. Section 22 provides that when a suit may be instituted in more than one court in view of the provisions of section 16 to 20 of the Code of Plaintiff Code, and the plaintiff being dominus litis chooses one court as per his convenience, a defendant may at the earliest opportunity and in all cases before settlement of issues file an application for transfer of the suit to any of the other courts having jurisdiction to try the same, and thereupon the court to which such application shall be filed and shall determine, after hearing all sides in which the courts having jurisdiction to try the suit, same shall be tried. Section 23 of the code relates to provision as to which court such a transfer application shall be filed. In section 23(1), subsection 1, it is provided that when the two courts having jurisdiction over a matter is subordinate to the same appellate court, in the event application for transfer can be made before the appellate court. But when the where the proceeding is pending, and the court which is sought to be transferred are not subordinate to the same appellate court, but they are under the control of the same High Court, in that event, as per clause 2 of section 23, the application can be filed before the High Court. while reading this judgment, one more thing is clear, that there is a possibility that there are 2-3 cases filed against the same person. Recently, there was a film actress where cases were filed against her all over country. Now here, she went to Supreme Court and she got it transfer at one place. So it can be tried at one place. It is not that she will defend in each and every places. So transfer is also when there is a FIR filed against that actress all over the country. Then she goes to Supreme Court that she can defend at one places, because the allegations or the reason for the FIR was lost was the same. So this is also one of the example of the transfer. Now we will go for judgment reading. Vandana Bhargav is the speaker, I would say reader for today.
Yeah.
Vandana, can you see the Savitri Pandey's this judgment?
Yes, ma'am. Yes, ma'am. I can see.
This
Yeah.
is a judgment by Supreme Court by Justice R.P. Sethi. Very beautifully written. And it is about the matrimonial dispute. See the words used and also the way it is written. It will give you a lot of material for drafting as well. Vandana, you can start.
Yes, ma'am. Thank you. Alleging cruelty and desertion against the husband, the appellant wife approached the matrimonial court under Section 13 of the Hindu Marriage Act, praying the dissolution of her marriage with the respondent by a decree of divorce. She also prayed for direction to the respondent to return her ornaments given to him at the time of marriage. The family judge allowed the petition and dissolved the marriage of the parties on the ground of desertion by the husband. The appellant was also granted a decree of rupees 12,000 towards the price of the scooter allegedly given at the time of the marriage and payment of rupees 500 per month as permanent alimony. Both the husband and the wife preferred appeals against the order of the family court, as the wife was not satisfied with the part of the order refusing to grant a decree in her favor in respect of properties claimed by her, and the husband was aggrieved by the order of dissolution of the marriage by a decree of divorce. Both the appeals were disposed of by the impugnant order, holding that the appellant wife herself was a defaulting party and neither the allegations of cruelty nor of desertion were proved. The order passed under Section 27 of the Hindu Marriage Act and for permanent alimony was also set aside. The grievance of the appellant wife is that the High Court was not justified in setting aside the findings of fact arrived at by the family court, and that she had proved the existence of cruelty and desertion against the respondent. It is contended that as the appellant wife was proved to have been living separately, it was to be presumed that the respondent had deserted her. The facts of the case giving rise to the filing of the present appeals are that marriage between the parties was solemnized on 6/5/1987. The appellant wife lived with the respondent husband till 21st June 1987, and according to her, the marriage between the parties was never consummated. After 21st June 1987, the couple started living separately. The appellant alleged that her parents spent more than rupees 80,000 with respect to the ceremonies of the marriage and also gave several articles in the form of ornaments, valuables, cash and kind as per the demand of the respondent. The respondent and his family members allegedly made further demands of color TV, refrigerator and some other ornaments besides hard cash of rupees 10,000. The father of the appellant obliged the respondent by giving him rupees 10,000 in the first week of June 1987, but could not fulfill the other demands of his parents. The respondent and his family members were alleged to have started torturing the appellants on false pretext. Aggrieved by the attitude of the respondent and his family members, allegedly made further demands of it was like color TV, refrigerator, and some other ornaments besides hard cash of rupees 10,000. The father of the appellant obliged the respondent by giving him rupees 10,000 in the first week of June 1987, but could not fulfill the other demands of his parents. The respondent and his family members were alleged to have started torturing the appellants on false pretext. Aggrieved by the attitude of the respondent and his family members, the appellant states to have filed a petition under Section 13 of the Act seeking dissolution of marriage by a decree of divorce along with prayer for the return of the property and grant of permanent alimony. The respondent also filed a petition seeking divorce and grant of other reliefs. However, on 14/5/1996, the respondent filed an application for withdrawal of his matrimonial case, which was allowed on 19/5/1996. The appellant had alleged that the respondent was having illicit relations with a lady residing in Gaya at Bihar, with whom he was stated to have solemnized the marriage. The allegations made in the petition were denied by the respondent, and it was stated that in fact the appellant wife was taking advantage of her own wrongs. On the basis of the pleadings of the parties, the following issues were framed: whether the defendant has treated the petitioner with cruelty, if so, its effect; whether the petitioner is entitled to relief under Section 27 of the Hindu Marriage Act, if so, its effect; whether the defendant is entitled to any relief, if so, its effect; to what relief parties are entitled. It may be noticed that no issue with regard to alleged desertions was insisted to be framed. With respect to the issue of cruelty, the family court concluded that no evidence had been led to prove the allegations. The court, however, held, but it is proved that the respondent had deserted the petitioner. Hence, the petitioner will get or is entitled to for a decree of divorce. On appreciation of evidence led in the case, the division bench of the High Court held, we also do not find any evidence that the wife had been treated with cruelty by the husband. We are also of the view that there is no evidence that petitioner is deserted. We have heard the learned counsel for the parties and perused the record. Treating the petitioner with cruelty is a ground for divorce under Section 13, subsection 1, clause 1A of the Act. Cruelty has not been defined under the Act, but in relation to matrimonial matters, it is contemplated as a conduct of such type which endangers the living of the petitioner with the respondent. Cruelty consists of acts which are dangerous to life, limb, or health. Cruelty for the purpose of the Act means where one spouse has so treated the other and manifested such feelings towards her or him as to have inflicted bodily injury or to have caused reasonable apprehensions of bodily injury, suffering, or to have injured health. Cruelty may be physical or mental. Mental cruelty is the conduct of other spouse which causes mental suffering or fear to the matrimonial life of the other. Cruelty therefore postulates a treatment of the petitioner with such cruelty as to cause a reasonable apprehension in his or her mind that it would be harmful or injurious for the petitioner to live with the other party. Cruelty, however, has to be distinguished from the ordinary wear and tear of family life. It cannot be decided on the basis of the sensitivity of the petitioner and has to be adjudged on the basis of the course of conduct which would in general be dangerous for a spouse to live with the other. In the instant case, both the trial court as well as the High Court have found on facts that the wife had failed to prove the allegations of cruelty attributed to the respondent. Concurrent findings of facts arrived at by the courts cannot be disturbed by this court in exercise of powers under Article 136 of Constitution of India. Otherwise also, the averments made in the petition and the evidence led in the support thereof clearly shows that the allegations, even if held to have been proved, would only show the sensitivity of the appellant with respect to the conduct of the respondent, which cannot be termed more than ordinary wear and tear of family life. No decree of divorce could be granted on the ground of desertion in the absence of pleading and proof. Learned counsel for the appellant submitted that even in the absence of specific issue, the parties had led evidence and there was sufficient material for the family court to return a verdict of desertion having been proved. In the light of the submissions made by the learned counsel, we have opted to examine this aspect of the matter, despite the fact that there was no specific issue framed or insisted to be framed. Desertion for the purpose of seeking divorce under the Act means the intentional permanent forsaking and abandonment of one spouse by the other without the other's consent and without reasonable cause. In other words, it is a total repudiation of the obligation of marriage. Desertion is not the withdrawal from a place, but from a state of things. Desertion therefore means withdrawing from the matrimonial obligations, that is, not permitting or allowing and facilitating the cohabitation between the parties. The proof of desertion has to be considered by taking into consideration the concept of marriage, which in law legalizes the sexual relationship between man and woman in the society for the perpetuation of race, permitting lawful indulgence in passion to prevent licentiousness and for procreation of children. Desertion is not a single act complete in itself. It is a continuous course of conduct to be determined under the facts and circumstances of each case. After referring to the host of authorities and the views of various authors, this court in Bipin Chandra Jaisingh Bhai Shah versus Prabhavati held that if a spouse abandons the other in a state of temporary passions, for example, as per anger or disgust, without intending permanently to cease cohabitation, it will not amount to desertion. It further held, yeah, can you just go down? Yeah. Yeah, you want me to read this? We have already finished reading this portion. Oh, ma'am?
Am I audible now?
Yes, yes, yes.
See, so many people ask me, how do issues are framed? Now, sometimes the judges frame the issue, sometimes they ask you to to give the issue, draft issues. Now, when you check this on the basis of pleadings of the parties, can you check this? On the basis of pleading of parties, the following issues are framed. So when you read judgment, you also get to know so many things. Here, easily you are getting how the issues are drafted. Sometimes, as a junior lawyer, even as somebody who has been practicing for decades may not know how to frame the issues. Now, here in a judgment, you get it readily. That is the reason I request all of you to keep reading judgment. This was a matrimonial dispute. Very good language was used. In fact, facts were also elaborated very nicely. In such cases, you must go through these judgments before you draft. So, whenever you go for drafting, go for reading at least 10 judgments of that particular high court, the state in which you are residing. If you are from Delhi and you are going to file a case in Delhi Family Court, find out the last 10 years few judgments, or at least last 5 years few judgments of the particular Delhi High Court there. Now, the next part is the vocabulary. Is it visible?
Yes.
Thank you.
Yeah.
We'll start with the point number 21. Crux. The most vital, decisive, or point of a case, argument, or legal issue. Now, we all use the word crux. What is the crux of the matter? The sentence is, however, the crux of the matter boils down to the following core issues. See, the word core issues is also important. Boils down is a English language in different, I would say, format, good language. The crux of the matter. What is the crux of the matter? That is what the judge may ask you. Or you can always submit your argument. The crux of the matter is so and so. Now, next is fiduciary. Fiduciary, the name itself suggests involving trust. Normally, it is used in the banking contracts. Disclosure of the declarations would be breach of fiduciary relationship. So, it is about the trust. Next is very important, perjury. The act of telling a lie in a court of law. See, when you speak something lie before the court, the other side, if they have a proof, they can file a perjury case against you. There are evidence to show that RW1, the respondent witness number 1, the conductor had committed the offense of perjury. So in a case, one more case, if you speak lie before the court. Repudiate. The name itself says cancel, terminate, or reject. Now, this is also mainly for the contract or in the banking transactions or civil matters. No insurer shall repudiate a life insurance policy on the ground of fraud if the insured can prove that the misstatement or suppression of a material fact was true to the best of his knowledge and belief. Arraigned. This is common, I'm sorry, commonly used in the criminal matters to bring a person to a court of law in order to formally accuse. The appellant was arraigned as an accused on the disclosure statement of the accused. Next is adduce, to cite as evidence. Now this is also very important. Do you want to adduce any evidence? This is the question the judges pose to you. The collector may, after giving him a reasonable opportunity of being heard and adducing evidence, impose a fine. So use this vocabulary when you start practicing. It will make your submissions very impressive. Rebuttal. Rebuttal is mostly used in 138 check bouncing matters also and civil matters also. A response to opposing argument, on easy words, counter argument. When somebody says something, you can counter, you can rebut. No evidence was adduced by plaintiff in rebuttal of evidence of defendant. Futile. That is useless. But you can't use the word it's a useless before the court. See, in court we have to use the gentleman's language. It will be futile exercise. It is further submitted since the witnesses were examined in sessions trial and they did not support the prosecution case. So it will be a futile exercise to face the trial. Next word is paramount. The most important, the word itself says paramount important. The judiciary has a paramount duty to safeguard the rights of the victim. See, only 10 words, but actually it changes the way we speak before court, and also it will give you impression that you know the law, and somewhere there is a confidence built up when you know the language better. So always do one thing, that whenever you go to the court, try to read the judgments. It will help you. Vandana, can you unmute everybody? Mute everybody. Okay. Now the most important part, वंदना सभी को म्यूट पे रख दो क्योंकि अभी बहुत अच्छा पार्ट है जो it will be I would say every lawyer has to learn it. It can't be taught in the books of laws. Even I'm still learning it, watching the other advocates arguing it, their behavior in the court. The word is courtcraft. Even if you put it in some legal portal, you will rarely find anything on the courtcraft. So that's why I'm telling you, kindly concentrate when I'm speaking on the courtcraft for the next 10 minutes. The meaning of courtcraft is a skill which everybody develops while talking to somebody. But when I use the word courtcraft, how I behave in the court, how I perform in the court is my decision. Now, this is nothing to do with the knowledge you have. This is actually a presentation of yourself in the court, your behavior pattern with the honorable judge, with the court staff, also with your opponent lawyers, your colleagues. See, when I started going to the court, the first thing I learned, going to court on time. That is, I won't say on time, go before time. One senior lawyer from the Andheri court told me, I still, his words ring in my, ears still, I can hear his words. ज्युनियरने ही टोल्ड मी इन मराठी ज्युनियरने कोर्टात 1 तासा आधी आलं पाहिजे द ज्युनियर मस्ट रीच टू द कोर्ट 1 hour in advance before the court starts working. So if the court starts at 10:30, you should reach 9:30. This actually percolated in myself, and still I try to be there at least on time, or I have a junior who will take care of the case in the court, because when you go early, your client is also impressed because you are before him. Sometimes the judge's car comes and you can greet them with namaste. Also, there is a possibility the staff comes. There are a few lawyers, senior lawyers, who come on time there, and you can interact with them. So this is also a court craft, because everybody in the court knows you, and your body language. When you go, see, if you go immediately at some place, you're new to that. Your body language gets settled in the court. So always try to go before time, 1 hour in advance. I have a video especially for junior lawyers in which I say that always reach the court before the judge car reaches, and leave the court premises after the honorable judge car leaves the court premises. So you are there from, I would say, 9:30 to 6:30. This always helps you. Now, another thing court craft is, when you are in the court premises, you can't wear color shirts or color clothes and go to the court, because there will not be a difference in civilians and you. You are also a civil person, but then you are an officer of the court. So you should always go with the court clothes. And now court clothes, everybody knows, I need not specify, it's black and white. And one more thing, I would say, I won't say you wear costly clothes, but you wear decent clothes, which impresses your clients. I recently had a meeting at Madurai with few lawyers, and one lady was asking me, there is a difference between the fees paid to the lady lawyers and the uh, male lawyers, men, male and female. I said empathically that I do not agree with it. Because why I do not agree with it? I remember Sri Devi was paid more than some male actors. I give this example. Why can't this happen? See, you have to command your fees. You can't demand your fees. You have to command. Respect is commanded. That is how, in the legal profession, I believe the fees is commanded. Of course, you can make some discount to the, or give some rebate to the, or you can go for pro bono cases in few of the matters where the client is unable to pay, the lady is unable to pay. I understand. There is a genuine case where a person cannot pay you, but you will have a clients which have good capacity, good paying capacity. The word used is good paying capacity. Now, how it will happen when you are presenting yourself in a better way? So I always tell that be presentable in the court. If you are wearing a white, it should be actually white. It should not dull white. It doesn't take much of money also, only little efforts to be presentable in the court. This is also court craft. Now, I will not mention the name of the honorable judge, but when I was in Supreme Court, I had gone to give my advocate on record exam. In a one function, the honorable judge said, those who were in uniform, proper uniform, properly were presentable in the court, I was little liberal to give them the good orders. See, when you say that you are giving good orders, the judge is saying, see, this is also percolating in my mind. That if you are, Vandana, can you mute everybody? It's a very important topic. So it is very important that when you go to the court, always wear the Okay, wait. When you mute everybody. Okay, keep a watch on this, who is speaking. So, code craft is one of the important part of your profession throughout your life. If you are, even if you are working as a corporate lawyer or as a legal counsel or as a legal professor or law professor, it is very important. So, when you go to the court, be in a presentable form. Now, when Supreme Court judges say there's some those who were the juniors who were properly dressed up in a white proper uniform, I used to give. I was little liberal to giving them orders. So you have to understand how it is. Now, another court craft, you should always be ready with your case. I have a colleague, Lalita, from my chamber. She may be today attending also. Today she has gone for a case and she handles it very beautifully. Still, I had spoken to her. This is what is to be done. You keep your papers ready, and she has all actually kept the paper ready. At 11:14 or 15, that is court starts 11 o'clock. I messaged her something, and she said the date has been given and the warrant is issued because the opposite client and opposite lawyer reached late to the court. Let me say, I won many cases, or I may say I got to settle many cases only for the reason that I was there on the time, and the opponent lawyer and his or her client came late. Now here also, Lalita got the warrant issued. I'm talking about today itself. She got the warrant issued against the accused, and in the afternoon she was there till in the court till because the accused lawyer came dilly-dallying at about maybe after 11:30 or somewhere. I do not know. But they came late after the case was called out. So we see, because our paper was ready for the warrant application, she got the warrant issued, and the exemption application of the other side client was rejected. Now see, we have the upper hand while settling this matter also, and while agitating this matter also before the court. And let me tell you, issuance of warrant makes a lot of difficulties for the accused in the criminal matters. Those who some are there, I can see some few lawyers here also. They understand the importance of the warrant in the criminal matters and how serious it is. It is not that easy that the warrant is issued and the police will come to your accused house and so many things. So you are in a better position to negotiate once the warrant is issued. But the warrant will be issued when you are ready there with the papers. You are ready on the time. Because if the matter is called at 11:10 and you reach the court at 11:50, not done. Reach on time. Another code craft which I have developed myself is if I go to the court, I make it a point to sit inside the court whenever my matter is called out. I will not take my phone calls from the family also. I'll hand it over to my junior that go and see outside what is the reason they are calling me. Normally they won't call me because they know I'm in a court premises. They will message me. But in front of court, I will not see the mobile, number one. I will watch the proceeding. I will look into the eyes of the judge. And when the judge sees you, that this lawyer is not going out, she herself, she or he, the judge itself, himself will ask, what is your matter, madam, if it is not called out? See, there are benefit of two, three things in the court when you sit in the court. First thing, whenever you sit there, you get to know the judge temperament, how he or she deals with the case. Number two, the judge also sees that you're sitting since morning. Thirdly, you also know that what is going in the court, how the judge decided, what are the dates given in the previous matters, which dates you can expect. Now, if the in the previous case, date of 2 months is given, you can't ask the date for 8 days. The judge, you will annoy the judge by asking the short date. When the judge has given 2 months date to everybody, unless you have a very cogent, true reason for asking the nearest date. So it is also very important. So code craft can go on, but there is so many things which you have to learn. Thirdly, I will also ask all of you to, when you sit in the court, mobile is one thing. I understand it's very important part of your life now. It's not a luxury now. It's a necessity. But people have survived without also cell phone. So when you are in the court premises, especially in the courtroom, if you keep on messaging every now and then, and this happens. And another thing which I have noticed, two lawyers talking, unless and until it's very important, the judge is watching you. If you talk, you're disturbing the proceeding of the court. Also, the judge's attention goes to you, and this is not the place. If you want to talk to your friend or the opponent lawyer or to the client, go out and talk. Don't talk in the court. मीटिंग में मीटिंग नहीं होती है. दिस इज व्हाट आई हैव हर्ड ओवर द इयर्स. कोर्ट में कोर्ट नहीं चलाना है. आपको कुछ भी बात करनी, प्लीज गो आउट, because when you disturb the complete proceeding, and it will reflect on your own case. Always remember this. When you speak in the court, you speak for 1 or 2 lines is okay. You see some seniors speaking, see, the court will not sometime not shout at the seniors, for the reason they respect their age or whatever reason, and they speak in a very different tone. I have heard that. But if a junior who is not used to any, if their voice goes to the judge's ear, then it may reflect, and judge may insult you or may shout at you, and that will actually demoralize you in the beginning of your career. So I request all of you, do not talk in the court premises, especially in the courtrooms. Also, one more thing I will always suggest, when you go to the court premises, also visit library, court library, because you meet good lawyers there who studies, who actually discussing some legal points. If you go to the court premises, law library is one thing you must visit. You get autobiographies, you get current judgments. Everything is not on Google. There is a magic in reading a law book than just Googling it. Google and AI will not give the answers, because if you read books on commentary, kindly note down books on commentary. If you have to file a divorce case, there are books on every court. There is one small book on the books on commentary. Please read it. There are seniors, ask them which commentary book I should read on criminal law, on civil law, about on the will. If you have to draft a will, don't make a draft, take the draft from typist. Go and find out the book on will and read it. It will actually give you lot of confidence, because your will, in your will, the words will be different and actually the legal words. So Courtcraft is something which you can keep on learning. And if it goes on like this, you will develop your own Courtcraft. And one more important incident I would like to share you. Never ever mention your case. Unless you are in very emergency, dire emergency. There is exigency. Let me use the word. Some urgency. You have to go to home. There is something has happened. Or you have another case. Then court will sometimes say, if you have case, so many case, send your junior. Don't ask me. This is one important thing I always tell. Never ever mention the case. I was in Supreme Court, in a Chief Justice Court. One junior, in between the, when board was called out, there were serial numbers it was going on. One person went, the junior lawyer, and mentioned the case. The court reprimanded him. The reason saying, can you see the board is continuous? And number one, the serial numbers are not completed. Also, there are, I have heard it myself, Chidambaram sir, Kapil Sibbal, and many senior lawyers were sitting there. And the Chief Justice said, if they are sitting and waiting for their turn to come, why are you mentioning as a junior in between the other cases before the court? See, this also is one of the best lesson we should learn. Never mention the case. Judge is not sitting idle. If the judge is not doing anything and talking to the interpreter or the typist, and you have some emergency, wait for your turn, stand up and say, may I mention a matter? There is a reason. Can I seek the indulgence of the court? So I always tell, do not mention unless there is emergency. Wait for your turn. And when you wait for your turn, let me tell you, you get good orders, or at least the judge is very kind in accommodating the dates. Also in accommodating, sometime I request the uh, judges on the dais, can I come at 3 o'clock? Can the matter kept in second session? So I need not go in early, because early in the morning, all the cases are called out and you have to still wait at 3 o'clock for your case to turn up because called out. The reason is if it is a parted matter, it will be taken up maybe sometime in the second or at 1 o'clock. So if you get poly with the judge, that you get acquainted with the judge, it helps your case, your clients, your time and everything. So this was the court craft, and I would request all of you to develop your own court craft, and slowly you will know how the court functions, how the litigants come, and so many things you will learn. And one more thing I can tell you, that spend some time in the courtroom premises, in the mostly in the not there are not chambers here everywhere. In Maharashtra we do not have chambers, except Solapur and Kolhapur there are some chambers. So you can go to the common rooms of the gents and ladies, the bar rooms. When you go to bar rooms, you meet so many lawyers, your faces also get acquainted with the other lawyers, and that they feel that you are a regular coming here. There also you overhear the conversation about the recent judgments which are discussed in the bar room. I have friends who has told me that I have grown up in the bar room. From junior days he used to sit in the court, and till date I see that he sits in the bar rooms. He said I have grown up. So bar room is also a good place to understand actually how the laws are developed, what recent judgments are pronounced by the High Court, Supreme Court, or other courts, and what is actually going on. So develop your own courtcraft and be a good lawyer. So this was all for today. If anybody has a question.
There are no questions for today's session.
Thank you so much. Shubh Ratri.
Good evening, ma'am.
Yes.
My name is Mahendra Reddy from Telangana.
Yes, sir. Tell me.
It's a very useful session, and also because we are learning so many things, madam, which is happening and occurring at the courts. Even basic things also you are neatly explaining. So we are fortunate to listen your class, madam. So personally, I am thanks a lot to and your team to give lectures to the aspirants and the advocates, junior advocates, and the final year LLB students also. Thank you so much, madam. Very beautiful, and it is a very bothering session, madam. So my wholeheartedly, I'm saying very thankful, madam.
Thank you, Mahendra, so much. I hope you can share this video with other juniors, because when I see
100%.
people here, 100 plus, I understand that there is a need for such kind of lectures, and there is a urge to understand actually how the practice goes on. It's one of the best field as a lawyer. If you, all of you have chosen, let me tell you, I am a first generation lawyer, but it's actually one of the best profession I have chosen, and I'm very happy about it. Thank you so
Yes.
much. It has given me respect, money, everything.
Yes, ma'am.
Thank
Yes,
you so
ma'am.
much.
Thank you so much, ma'am. Thank you so much.
Thank you. We'll end the meeting for today.